Well, good morning, everyone. This is George with the Pennsylvania Office of Open Records. I'd like to welcome you this morning to our webinar where we're going to be talking about basics of the right to know law, where we give you essentially a foundational body of knowledge of Pennsylvania's open records law and how it all works. Couple items to take care of preliminarily here before we jump into the actual session. First, this session is basically a PowerPoint presentation with me talking in the background. The PowerPoint, if you're interested, is available on the website. You would scroll over to the training tab and go down and you'll find the choice where you'll find all of the PowerPoints that we use for our trainings, including these webinars. Feel free to download any of those that you need. It's possible that you have a friend or colleague who couldn't attend this morning and they might benefit from looking at it. Maybe just for your own future reference, it would prove helpful, or maybe you're conducting some local training and you're welcome to use any of the resources that we have available for you. This session is being recorded, and typically the way it works is that it takes a few days for the administrative staff to get everything in place, but if you're interested in getting a copy of the recording, you can email or call into the office with your request, and they will send you a link that then gives you access. And again, you can download it if you feel inclined to do so, and you're welcome to use it for whatever purposes you feel is necessary. It is a public record. Finally, if you have any questions, you can use the chat feature to type in your questions, and I'll do my best to get you headed in the right direction. A couple things though, I can't write your requests for you. I can't answer requests for you. Our office does not provide legal advice, and we can't discuss any active appeals that anyone might have before the office. But that being said, I have two things to ask you. First is, we're talking about the right to know law today, so let's keep our comments and questions on point. The second thing is probably more important, and that is the briefer and more concise you can keep your questions, the better. Occasionally, folks will type in several paragraphs, and it's just awkward for me to sit here and read through it, excuse me, while everyone else is waiting patiently. Look, if it appears that you've got an unusually complex question or something that is just specific to your situation, we'll do one of two things. We'll wait until the end of the presentation, and I'll come back to it and answer it for the good of the order, or we'll take the conversation offline, where again, you can reach out to our office. The phone number is on the screen now, as well as the URL for our website. On that website, there are email accounts that you can avail yourself to and type in your questions. And the first step is that when you contact our office, you're put in touch with one of the administrative staff. And they are very well versed in the law and can usually get you headed in the right direction. If you happen to stump them, your question gets escalated up to one of the senior staff, and we do our best to get back to you in a timely manner. And like I said, we do our best to get you headed in the right direction. Okay, so all that being said, let's go ahead and dive into this and talk about the right to know law. And let's begin by talking about, why it is the right to know law and why is it important? And I think the first thing I want to do is mention the purpose of the right to know law, which is fairly straightforward, but it's interesting. There's a lot of misunderstanding. People see that term, right to know, and they interpret it as, okay, this is some sort of Google for state government, state and local government. And it's fascinating, some of the questions that we see come through, but it's not. I mean, the purpose of Pennsylvania's right to know law is to give the public access to public records. Okay. Looking at that, you may think, well, yeah, that's an awful lot. Or you may think, well, that's not much at all. But when we parse down what the right to know law is all about, this is it. And for those of you who might be agency open records officers or right to know officers, the two terms aren't interchangeable. Sometimes you will get a right to know request and it's just, maybe it's vague, maybe it's not clear as to what the person's asking for. Maybe given the nature of the request, it's a little confusing as to how to proceed. And my advice, whenever that happens, is to go back to this fundamental statement. Okay, my job is to give this person access to public records, no more, no less. Now, that being said, there are some conditions that we need to discuss. And the first is very important in that when you look at the right to know law, the presumption is that every record in the possession of an agency, and when I use the term agency, that's a generic term. It could be, a state's cabinet level department. It could be a board, a commission, an authority, any entity created by statute. At the local government level, we're talking cities, boroughs, townships, authorities, again, school districts, by an extension of school districts into public charter schools, and the like, okay? So every record of one of these agencies is presumed to be public. That's our starting point. Unless the agency can make a successful legal case that the record should not be released into the public domain. But it is the agency that bears that burden. Now, if you're new to the world of right to know, and let's say you're working on the agency side of the equation, you hear that and it sounds rather daunting. You get wigged out. It's like, oh my gosh, everything in the office is going to end up on the front page of the newspaper tomorrow or on somebody's Facebook page or whatever. And I'm here to tell you that that is not the case, okay? There are protections that we'll be discussing built into the right to know law, as well as other laws that if a red flag goes up when you receive a right to know request and you're thinking, I just don't feel comfortable that this information should be released, chances are that one of these tools will come into play. And it's the appropriate use of that tool that allows the agency to establish the legal case as to why the record should not be released into the public domain. But be warned, it's not just a matter of saying, well, that's none of your business. That doesn't work, okay? You have to make that legal case. And maybe the better term is legally acceptable case as to why the record should not be released into the public domain. But bear in mind, it is the agency that bears that burden, not the requester. Okay, the requester can sit back and expect to get a successful response to their right to know request unless the agency can successfully prove that this is not a public record. Therefore, we are not or we cannot release it. I also want to emphasize that the right to know law is not a confidentiality law. Okay, what does that mean? Well, there are a couple points that I want to clarify here. First, an agency can give out public records without ever touching or mentioning or even thinking about the right to know law. There is nothing in the right to know law that prevents an agency from giving out a public record if it wants to. And there's nothing in the right to know law that requires that an agency must have a right to know request in order to give out a public record. Now, an agency can require that a requester use a right to know form, but they don't have to. Okay, they can just give out a record. Here's a quick example. Let's say it's budget season and I'm Joe Q. Citizen and I walk into my township office and there's a stack of budgets on the counter and I ask for one. There's nothing preventing the person at the counter from simply handing me that copy of the budget. And let's even escalate it a little bit. Let's say I have a right to know request that's asking for a copy of the budget. There's nothing preventing the person behind the counter from saying, you know what, Mr. Spees, if you tear up that right to know request, I'll hand you a copy of the budget. Now, why wouldn't I do that? Number one, it's saving the agency a lot of work because now they don't have to go through the right to know process. And it's saving me a lot of time because I'm walking out of the office immediately with what I came there for. So, like I said, there's nothing preventing the agency from saying, look, we'll give you the record, just tear up the right to know request. But if I say, for whatever reason, you know, and I don't know what a good reason would be, but if I say, no, I want to follow the right to know process, well, then you have to do that. And it could take up to 35 days before I even get a response as to whether I'll get that copy of the budget or not. But, you know, I'm allowed to do that because the law dictates that. Okay, one of the things that, you know, working around the right to know law that we encourage agencies to do is to be proactive. You know, we have all these social media resources available to us now, some at virtually no cost, other than the time and effort that it takes to use them. And what we encourage is agencies should be proactive with posting records that are commonly requested. I recommend taking a look at your right to know request history and identify trends. What are people asking for? What records are they typically seeking? And then take those records and post them to your websites. Use your websites as business platforms. So stuff like budgets, contracts, salary information, purchasing documents, records that are commonly being requested, that are clearly public at face value, you put them on your website. The right to know law then allows you that the next time you would receive a request for one of those records, your response is, that's on our website, here's the link. And end of story, okay? It's in the right to know law. It allows you to do that. What you'll notice is that hits on your website or whatever social media platform you're using, that will go up and the right to know requests will start going down. And I think this is part of the trend that we're seeing in modern society where people's expectation, where they would much rather sit in the comfort of their family room on their laptop and surf your website to get the information and the records that they need, as opposed to conceivably having to take an afternoon off from work, come down to the office during business hours, file a right to know request, and like I said, potentially wait up to 35 days before they even get a response to their request for what otherwise would be clearly a public record. So be proactive, be customer friendly, good government, put this stuff on your websites, and I think it'll make your life a little easier for everybody concerned. Okay, so your agency comes under the right to know law's jurisdiction, and there are some things that you have to do. Probably most importantly, you have to appoint an agency open records officer, what we call an ARO. Right to know officers, the same thing. Like I said, the two terms are interchangeable. This is the person who receives, processes, and responds to right to know requests, okay? They have a certain legal burden that they need to carry. But this could be the person, there's nothing in the right to know law that dictates this person needs to be at a certain level within the organization. It could be the school superintendent. It could be the nice person who greets you as you enter the administration office door. There's no limit to the number of open records officers an agency can have. Like I said, they don't have to be at a certain level. They don't even have to go to training, but we certainly encourage that they do. And to those of you who are on the agency side of the equation attending today, I applaud you. And like I said, if you have any questions, let me know. But you have to look at it from the public's perspective, okay? This is an important person in the process. So if I come into your office, one of my first questions is going to be, who do I give this right to know form to? So make that clear. Who is the arrow? Okay, so that, again, look at it from the public's perspective. They have a problem. You can help them solve that problem. So the easier you make the process, the easier it's going to be for you in the long run. Now, an agency can also come up with their own local policies in how they administer their open records program, as long as it doesn't conflict with the law or any policies that are promulgated by the Office of Open Records. Here's a quick example, and it's very germane because there was just a court case, I think it was probably a final determination ruling on this, where, for instance, in the right to know law, there's a provision, and I'm paraphrasing here, that basically says an agency may accept anonymous requests. Well, there's another law in Pennsylvania. It's called the Statutory Construction Act, where because the right to know law has that term may in it, it also means may not. So you parse this back, and the result is that an agency can have a policy that says we will not accept anonymous requests. Everyone who submits a request must identify themselves. So you can have a policy that says we will not accept anonymous requests. It doesn't conflict with the law. It doesn't conflict with anything from the Office of Open Records. And there are many agencies that do this. You can create your own right to know request form as an agency, and many of them do. They like to have their seal at the top. Perhaps they have contact information for the arrow, any of those local rules that they have put in place, and so forth and so on. But you must also accept the state form, which nothing necessarily special about it. It's on our website. You can link to it if you want. But if someone comes into your office with the state right to know form, you must accept that. And then finally, we ask that you let us know here at the Office of Open Records who your arrows are. On our website, and you'll hear me refer to this website quite often, we have a database of all the open records officers from across the state. Now, it's a voluntary system for the most part, where we depend on you to let us know who you are. So one of the takeaways here this morning is check our website to make sure that your information is up to date, because people move on, they get promoted, they retire, they move from one agency to another. So this changes, but if the information is not up to date, that creates a problem. It's not unusual where we get a call from somebody and they said, look, I can't find any information on XYZ Township's right to know officer. What do you got? So we'll steer them to our website. And if the database is off, then that's a problem. Also, if we get an appeal filed here, we use that database to reach out to the agency, assuming that we're notifying the correct person that you have an appeal. So it's important that this be kept up to date. If it's not accurate, there's a form there that you can fill out, email it to us, we verify it, and then we update the database. Okay, so that would be very helpful. You have to have postings within your agency. And again, educate the requester using these posters. They have to be physically on your bulletin boards in your administrative offices. And if you have a website, they have to be on your website. Those postings need to have the contact information for the arrow. Remember what I said. Who do I give this right to know request form to? If by chance you end up denying the request, then you have to detail, you have to notify the requester what are their appeal rights. Now, in 95% of the cases, it's going to be you file your appeal with the Pennsylvania Office of Open Records. We recommend that you put down the URL for our website because the greater majority of appeals can be filed right on our website that feeds into our docketing system. And it just makes it easier for everybody if you put down that contact information. Then if by chance you require that they have a form when they file their request, but they don't have one, you have to have a blank form available for them, whether it be on your bulletin board or you can hand it to them or online, again, if you're using your website. And then finally, detail any of those local regulations, policies, or procedures that your agency may have adopted in administering your right to know program. Let me get a quick cup of coffee or sip of coffee here. Okay, some things that you can't do under the right to know law that an agency can't do. Well, you can't limit the number of records or requests that a person files within a specific period of time. You can't say something to the effect, you know, ma'am, I'm sorry, but you've already filed 3 requests this week. That's all you get. If she's inclined to file a dozen requests, she can do that. Also, you cannot compel a person to tell you why they are filing a right to know request. You can't deny a request based on the reason or what you think that reason is, even if it's just to see you work harder. Let me go off script a little bit here. I'm the first to acknowledge the greater majority of people using the right to know process have a legitimate problem, and they're attempting to solve that problem by getting a public record. And they're willing to pay a nominal fee to do that. However, there are a handful of people who, for whatever reason, the relationship between the agency and them has broken down. Maybe they don't like who got elected last time. Maybe they got, a parking ticket. Maybe they just, had a run-in with the local police department. Who knows? But they've decided they're going to be a pain in the neck. And one of the ways that they're going to be a pain in the neck is by weaponizing the right to know process. Originally, well, going back quite a few years, I was the open records officer for the Office of Open Records, handling over 1,000 right to know requests a year. And we had a couple of these people. And my experience is that if you're dealing with what we call a difficult requester or problem requester, some diplomatic phrase like that, the solution lies on the payment side of the right to know law. Most people are willing to pay a nominal fee to get a public record. Difficult requesters are not willing to spend a dime to be a pain in the neck. So if you can come up with a legitimate cost, chances are they go away and they're no longer a problem. Now, we offer a webinar that's put out there regularly on the payment side of the right to know law. I would suggest sitting in on that because, again, there are a lot of misunderstandings. People think right to know is free. It's not. There are costs involved. And like I said, if you can come up with a legitimate cost, most problem requesters will go away. Okay? Let me get back on script now and continue to talk about basics of the right to know law. So you cannot compel a person to tell you why they're filing a right to know request. I like to describe the right to know process as an obstacle course. And just, finishing up the 2024 Olympics, I think I was kind of reminded of this watching some of the events. You've got the start of the process, which is when the request is received by the agency open records officer. Then you've got these hard deadlines built into the process. There's no wiggle room because this is what the law says, the courts have affirmed, this is what the law says, therefore you must follow these deadlines without any room for flexibility there. Very similar to a time standard. Not just anyone can enter the Olympics. They have to qualify by meeting certain standards in order to make it onto the obstacle course. Then on the course itself, you've got 2 hurdles that you need to jump over. And when you get to the second hurdle, you've got 3 hoops that you've got to make it through before you can even jump over the hurdle. And it's only when you jump over that second hurdle that you've finished the race, where the agency is saying, yes, this is a public record, and we're going to grant your request and give you that record that you've requested. All right, so let's jump into this obstacle course in a little more detail. Okay, when the agency receives the request, it should go to the agency open records officer, and the first thing that they should do is note on the request when it was received, okay, because that starts the clock ticking. Note the date on the request, whether it be a timestamp or you just write it in the corner, however you choose to do it. Because the agency now has 5 of its business days to provide an initial response. Now, a business day is when the office is open for administrative business. Typically, we would look at that as Monday through Friday. However, a holiday is not a business day. If you're closed for a weather emergency, that's not a business day. Police department, 24/7 operation, okay, but chances are the administrative office is only open during normal business hours, so we would look at it as Monday through Friday. And then when you get into some of the smaller municipalities, they may not be open for business 5 days a week. There are, for instance, some small townships up in the northern tier of the Commonwealth that may only be open, let's say, 2 days a week. Okay, so let's map this out as far as their business days. Let's say the request is received today. So tomorrow would be the first business day, Thursday. And let's say they're open Thursdays and Fridays. So tomorrow would be the first business day, then Friday, then we go to week 2, Thursday, Friday, then we go to week 3, Thursday. So close of business Thursday on the 3rd week would be the end of their 5th business day. You see how that works. And this could apply to small jurisdictions. It could apply to school districts that may not be on a full schedule during the summer. Years ago, I had a case where the request was submitted to Indiana University of Pennsylvania on December 16th. That was the same day that winter break started. The first day didn't occur until January 20th, over a month later. So you see how this, this all works, okay? Then the other thing that the agency must do is maintain a copy of the request. Now, the right to know law says 30 days or until all appeals have been exhausted. Now, the appeals can go all the way up to the Pennsylvania Supreme Court, and that conceivably would take years. So, if you have an active appeal, you want to hang on to everything. But if for whatever reason the appeal period has expired, then the right to know law says 30 days. But again, there is another law in Pennsylvania. It's called the Pennsylvania Municipal Records Act. Now, that law controls all of the records that townships, boroughs, cities, and the like come into contact with, and it establishes a time frame for how long you should hold on to this stuff. That law says 2 years for right-to-know materials. I feel more comfortable saying hold on to things for 2 years than as opposed to 30 days, because within 30 days, there may be something going on that you're not necessarily aware of that could come back and say, this appeal is still active, okay? It just happens sometimes. Not a lot, but I would recommend the 2 years. Then after 2 years, if there's no appeal pending, you can dispose of the records as needed and as dictated by the Municipal Records Act. And if you're not familiar with the PA Municipal Records Act, it's administered by the Pennsylvania Historical Museum Commission, Bureau of Archives, State Records Center. It's on their website. It's an excellent resource, and I would recommend taking a look at that, particularly if you're interested in record retention. It's just another good resource available online from state government. Okay. The agency is given the 5 business day period to provide an initial response. If they're unable to meet that deadline, the law does allow them to take an extension. That's a 30 calendar day extension. Now, a calendar day is different from a business day, obviously. Calendar day, you look at your calendar and you simply count 30 days. That would include Saturdays and Sundays. It would include holidays. It wouldn't, emergency weather closings would not count. Well, it would count as far as 30 days, but you don't get a pass just because you closed on that. So in order for the extension to be valid, though, there are some conditions that need to be met. First is it needs to be invoked during the initial 5 business day window. You can't wait until what would otherwise be the 6th business day, realize, oh, I forgot about this right to know request. Well, I'll just take an extension now. Unfortunately, when you cross the deadline, you denied it the request by default. Legally, it's what we call a deemed denial. If you ever hear that term, that's what it means. Where the agency failed to respond in a timely manner. So it's now considered denied. Then you have to notify the requester in writing that you're taking the extension. And, if the email was, if the request was submitted by email, then you simply reply back by email that we're taking the extension. You need to provide a reason why you're taking the extension. And if you go to section 902 of the law, it lists 6 reasons. And you simply pick the one that, that appears appropriate. It could be, we keep these records off-site, and it's going to take us longer than 5 business days to sort through them to see what we have. Or it could be, we want our solicitor to review the records to make sure we're not giving out anything we're not supposed to. And that's going to take longer than 5 business days. Then you provide a date that the requester can expect to get their response. Typically, that's on the 30th day of the extension. And then an estimate as to any costs that the requester can expect to incur. And it's just an estimate. It's not a hard quote. Sometimes it's a little high, sometimes it's a little low. You settle up on the exact amount when it comes time to provide the actual records. So you've got the 5 business days with the potential for the 30 calendar days tacked on to the end of it, which is why we refer to the 35-day window. Now, let me just point out here, though, that if the agency receives a right to know request and it has the resources to do so, and the request is for records that are clearly public in their nature, okay, don't just automatically invoke the 30 calendar day extension if you don't have to. There are some agencies that do that, and it's kind of like throwing cold water on the process. It's not good government. It's not customer friendly. You know, if there is a record that is readily available and it's clearly public, you should try and get it out to them within that, or get your response out to them within that 5 business day window. You know, enough said. You know where I'm coming from with all this. Okay. Moving on after another sip of coffee. We are now up to the first hurdle. And to make it over this hurdle, we need to answer a question. Is it a record? Okay, that seems kind of like a no-brainer. But whenever you're trying to understand a law and how it works, I strongly recommend don't forget the definition section of that law. Because oftentimes when you're reading through the verbiage, you know, it can have a lot of legalese. It can appear vague. There are sections that appear to conflict with one another. Oftentimes, you can gain clarity by reading the definition section. And the right to know law is no different. It happens to define what a record is. And this will become obvious as to why this is important here in a moment. Any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is, et cetera, okay? The key phrase in red and italicized here, documents a transaction or activity of an agency. Okay, English, what does this mean? Well, it means that a record needs to be about what it is the agency does. And you're thinking, why wouldn't a record document what an agency does? Well, all day long, we generate communications that don't rise to the definition of a record. Let's say I send an email to one of my coworkers. Did you hear about the new restaurant that's opened up downtown? Let's do lunch tomorrow. Okay, nothing to do with the Office of Open Records. Therefore, that communication is not a record. What do you think of the Eagles and Saquon Barkley and how that's going to affect their chances of making the playoffs this winter? Okay, great question, but does it have anything to do with work? No. I'm going to pick up a pizza on the way home from work tonight, okay? All common communications that you would find in a work setting that do not rise to the definition of a record. Therefore, if someone were to submit a right to know request for George Speece's emails, those communications would not be included because they are not records. You don't make it over the hurdle, you're off the obstacle course, request is denied, or at least those particular communications are not included in whatever response is sent out, because they're not even considered records under the right to know law. Now, a word of warning here, because this always comes up. Let me change the example around a little bit. Let's say instead I'm at home in my family room on my personal computer, on my personal Gmail account, and I send a communication to one of my coworkers. Let's say it's Nathaniel Byerly, the Deputy Executive Director. And it's something like, Nathan, I'm working on a session dealing with specificity of records. Would you send me the latest court summaries where this issue was discussed by, let's say, the Pennsylvania Commonwealth Court? Okay, now that's clearly work-related. And just because I'm sending it from home on my personal computer from my personal Gmail account has no bearing on whether it's considered a record or not. Okay, one of the very first legal opinions released on the right to know law essentially said you cannot use personal devices or personal accounts to hide the public's business. And what that basically means is that when a right to know request is submitted and the agency is conducting a good faith search for responsive records, my laptop is not off limits. Same way if I were to use my personal cell phone to send text messages, emails, Discord messages, which is something I've just learned about in the last year, if it's about work-related items, then any message on those personal devices and personal accounts are fair game. They are what we call discoverable under the right to know law. Okay, so keep this in mind. All right, so now we need to move on because we've answered the question whether or not it is a record. If it is a record, we've made it over the hurdle and we proceed to the second hurdle, where now we have to answer the question that's a little different. Is it a public record? Well, remember I said we have 3 hoops we need to make it through before we jump over the second hurdle. The first hoop, we have to answer the question, are there any exemptions that apply? And if so, are we going to invoke them? All right, what the heck is an exemption? Well, you go to section 708B of the right to know law. And by the way, if you need a copy of the law, it's on our website. It's under the first tab under right to know law. It's not necessarily a big law. It's not like a long 100-page document. And for the most part, it's written in common English. There are some areas that, you can tell the lawyers had a field day, but, for the most part, it's not hard to understand. So you can download it for free and, have an exciting time reading through it. You'll be on the edge of your seat, but it's there. Okay. So 708B lists 30 exemptions. An exemption is a definition of a type of record where the agency can withhold from public release if it wants to. It covers a broad span of types of records. And when you look at them, you think, regardless of whether you're a requester or working for an agency, hopefully you look at these exemptions and realize, well, yeah, I would never release a record like this. For instance, 708B1, I think paraphrasing, you can withhold a record that if it were released, it would put someone in physical danger. Okay, yeah, that makes a lot of sense. There's another one that says you will not release, or we will not release health records for any of our employees, or anyone for that matter. There's another one that says any records that would provide information about a minor, okay, you can withhold. All right, but remember when I said the right to know law is not a confidentiality law? An agency can release a record that's clearly covered by an exemption if it wants to, with certain conditions. And I'm going to talk about those conditions now, because we have to answer the second question, which is the second hoop. And that is, are there any federal, state statutes or a judge's order that says these records are non-public, these records are confidential? And usually, if there is another law that says a record is confidential, there is no discretion that allows the agency to release it to the public the way the right to know law has that discretion. And if there is another law that says this record is confidential, that trumps the right to know law. And that's explained in section 306. Okay, so let me just repeat this and break it down a little bit. If there is any other law that says a record is confidential, whether it's included in the exemptions of the right to know law or not, that law supersedes, it trumps the right to know law. And usually the agency would not be able to give that record out. And they could use that law and its confidentiality provisions to meet its legal burden in saying this is not a public record. I'll just give you a quick example. I mentioned health records. Okay, technically, if you look at the right to know law and someone submitted a right to know request for George Spiessa's health records, the agency could release them if they wanted to. But you could get into the federal ABC laws, alphabet soup, of health-related laws, HIPAA, FMLA, ADA, and the like, that all say health records are confidential. You don't give them out, and if you do give them out, you could end up in really, hot water. So the agency could defer to these federal laws that say we're not allowed to give these out. We have to deny your request. That's how that works. Okay, and then let's say that there are no other laws like that. So we've made it through the second hoop. Now we come up against the third hoop. And here we have to answer the question, is the record protected by privilege? For our purposes, we're mostly talking about attorney-client privilege. Attorney-client privilege makes confidential any communication between a lawyer and their client involving sensitive information. In our case, it's usually a solicitor and the mayor or council or senior management, whoever. Okay, those communications, whether it be emails, reports, and the like, are covered by attorney-client privilege, which is supported by statute and the rules of evidence in Pennsylvania, and referred to specifically in the right to know law under Section 305. If it's protected by privilege, you're off the course, okay? You didn't make it to the finish line, it's not a public record, and we're going to deny your request. If attorney-client privilege doesn't come into play, you make it through the third hoop, you can now jump over the second hurdle, and we are saying it's a public record, and we're granting your request. Congratulations. Okay, so now we have to take a look at, is there a cost involved? Okay, if we're going to grant your request, is there anything you have to pay for? And it turns out that there is a fee schedule. Again, it's on the website for open records. And there's a couple things that we need to keep in mind. First offhand, Section 701 of the law, I'll just paraphrase here. It says the agency is only required to provide the record in its current medium. Okay, what does that mean? Well, it's electronic versus hard copy. So if I submit a right to know request and let's say I submit it by email, and I submit it for a specific record, and I say I want it sent to me electronically. And I'm doing that, number one, because it's easy, number two, because there's no cost for electronic records. Well, if the agency doesn't, let's say the agency has the record, but it doesn't have it in electronic medium, it doesn't have to scan it in order to send it to me, because that would be converting it from hard copy medium to electronic. So the agency's response would be something to the effect, we have that record, but it's hard copy, and we'll provide it to you by making a copy of it, but then we can charge you for that copy. Do you want to proceed? And that's typically how they would respond to that. Now, if they have it in electronic medium, well, then they have to send it to you, provided it's a public record, and there's no charge for electronic records. There's also a provision within the right to know law that allows a person to decide, I don't want a copy of the record, I just want to inspect the record. But when they do that, the agency's in the driver's seat. It's the agency that decides, when during normal business hours, it's convenient for you to come in and take a look at the public records that you've asked to see. And the agency can supervise the inspection, okay? They can watch you to make sure you're not stealing anything, you're not altering any records, you're not destroying any records, okay? But they're in the driver's seat during this whole process. However, if you take out a cell phone camera and snap a picture of the record, you're allowed to do that, okay? It's a public record, and you can take a picture of it and use it as you see fit. The agency cannot charge for labor. They can't assess what's called a redaction fee, where, if we have to black anything out, we're going to charge you an extra $10. They can't do anything like that. And they can't charge you for any sort of legal review. That's just considered the cost of doing business in the government. All right, so they can't assess any of these extra fees. They can only charge you for actual costs that they can document, like postage is a good example, okay? What we call pass-through costs, okay? But other than that, it's all outlined on the fee schedule on the Open Records website. You kind of get the drift of where I'm coming from here with some of my comments, but I really advocate no surprises, okay? Look at it from the public's perspective. The more information you can put out there about the process that they're entering into in order to get a public record, the better. People don't like surprises. They don't like roadblocks. So the better you can let them know what to expect, the easier it's going to be for everyone concerned. If they run up against constant surprises and roadblocks, it's going to frustrate them, it's going to make them angry, and they're going to take it out on the agency open records officer. So be proactive, get stuff out there that's going to help them through this process. Communication is good. There is nothing in the right to know law that prevents a requester and an agency open records officer from talking to each other. So that if there's a request that's a little vague or confusing, the arrow can pick up the phone and ask for clarification. If it's not quite clear to the person, the requester, what record it is they need, they can call up and ask, is this what I'm looking for? Is this going to help me? Okay, and maybe as a result of that conversation, who knows, the right to know request won't even be needed. But, if it's filed, it's filed. But the better you can talk to each other and be clear on what exactly it is that's being asked for, what exactly the agency has available, the better it's going to work out. Same way with costs. When you receive a right to know request, do a quick estimate. And if you think, well, this is going to cost about $30, pick up the phone, contact the requester before you begin processing the request to see if it's okay for that $30 charge, because they may be under the misunderstanding that the right to know law is free. And if there's a cost involved, some people are going to say, well, yeah, that's reasonable. That's what I was expecting for this size of a request. Or they may say, no, wait a minute, I misunderstood. I thought this was free. I'm withdrawing my request, okay? Now, the right to know law does have a provision in it for really large responses where it's saying, I like to refer to it as a security deposit, where occasionally you will get these big requests, like a right-of-way for a road project. It could be thousands of pages, environmental impact studies, traffic studies, and the like, okay? And there are groups, some engineering outfits, some environmental groups will want all of this documentation. So you see these big requests come in. If it appears that the response is going to exceed $100, the agency can demand full payment up front. And they can wait for the check to come in, and when the check has cleared the bank, then they begin processing the response. And you settle up on the exact amount when we know exactly how many pages are going to be part of the response. Okay, that prevents the agency from getting stiff for doing a lot of work, for making a lot of copies, and then the requester balks on payment. Okay, so that all works out. Then there's another part in the law, Section 905, that deals with record discard. Okay, and this particular scenario doesn't happen all that often, but it brings to light a point in the law that I want to make sure everybody understands. And it is that if someone submits a right to know request and a cost is incurred, and then that person fails to pay for that cost, the next time that person submits a right to know request, the agency can deny processing the request because there is an outstanding debt. Okay? It doesn't have to be for the same group of records. It can be for a right to know request for an entirely different set of records. But if there is an outstanding debt, the agency can deny processing any further requests until that debt is settled. There's no statute of limitations on this. It could be a month, it could be a year, it could be 5 years. Okay. However, keep in mind that because it is a denial, it can be appealed. And if you go to our website, go to the final determinations database, which is searchable. You can simply put in the string fees and a couple dozen decisions will come up, and you'll be able to see how our office has ruled on these situations. So from the agency's perspective, you want to make sure you've got all your documentation in place, all the I's are dotted, all the T's are crossed, because if it gets appealed, you'll be expected to submit that information supporting your denial, supporting why there is an outstanding debt. And usually, if all the I's are dotted and the T's are crossed, the appeals officer will agree with the agency and say, yes, there is an outstanding debt that's legitimate, and until that debt is settled, the agency no longer has to process any right to know requests from this individual. So that's an important point to keep in mind here as you're managing your open records program. Okay, let's say that the person didn't make it through the obstacle course and you're issuing a denial. The agency's issuing a denial. Well, you have to issue a denial letter, and there's a certain format that needs to be followed. First thing you need to do is describe the records that are being requested. Okay, you're thinking, well, why would you have to do that? Well, sometimes it's not entirely clear what a person is asking for. They're not an attorney, but they play one on TV, or, it's just unusually vague, and you weren't able to get a suitable answer through a phone call or whatever. So you say, this is what we believe you're requesting. Okay, and then based on that, you decided these aren't public records. So now you have to describe the legal and factual ground as to why you're denying it. Why aren't these public records? Remember when I said that the agency bears the legal burden? This is where the rubber hits the road. This is where you have to meet that burden. Typically, you would refer to one of those exemptions within the right to know law. And you're saying, okay, you're requesting records related to the borough's computer system. And by releasing those records, we would risk the integrity of our computer network. So we're invoking 708B, I think it's 3. And these are not public records, so we're withholding them. So you would make that nexus between the appropriate law and the records that the person is requesting. Okay, and then you put the contact information for the arrow. Remember, this is the person legally responsible for responding. And you also note the date of the response, because this is important. It deals with another deadline that we're up against. and then the procedure that the person should follow to appeal your denial. And usually it's that the person has 15 business days to appeal to the Pennsylvania Office of Open Records. There are exceptions, but for our purposes, that's the one we're going to focus on here this morning. So 15 business days, and it's 15 of the Office of Open Records business days. We follow the state holiday calendar, even though we're an independent agency. But you can, for the most part, this is the requester's issue now as to filing the appeal in a timely manner. And, just make sure that you're not waiting until the last second, because you could end up, missing your deadline. And if you do, the appeal is going to get dismissed. Okay, so what happens when an appeal is filed? Well, we're getting near the end here, so I'm going to go through this kind of fast. We look for a copy of the original request, a copy of the agency response, provided there was one. The person has to provide a statement as to why they believe the records are public, and then a second statement as to why they believe the agency's denial, if there is one, is incorrect. If any of these elements are missing, we issue what's called a deficiency order, and we give the person 2 or 3 days to correct the deficiency. If they fail to do that, the case gets dismissed. If they're successful in doing that, the case gets docketed. When a case gets docketed, it gets assigned a docket number, it gets assigned to an appeals officer, and we send out a notice to the parties that we have an active appeal. Now, this could be the most important slide that you see here this morning. When an appeal is filed, everything I've described up to this point is an administrative process. But the Pennsylvania Supreme Court has defined the Office of Open Records as an independent quasi-judicial tribunal. That's a mouthful, but basically it means we are a court. Okay, and because we are a court and our decisions can be appealed to higher level courts, everything related to an appeal has to follow various legal procedures and format. Okay, so if you are an agency open records officer and you get the notice of appeal from our office, do not walk to your solicitor's office and notify them immediately that you have an active appeal. Because in essence, it's like someone is suing you. And if you miss the deadlines, and there are tight deadlines built into the appeal process, you could be abrogating your ability to proceed with the appeal effectively. As an agency open records officer, you're not expected to respond to appeals on behalf of the agency. That falls into your solicitor's list of duties. Okay, so they're the ones expected to be the point person, not the agency open records officer. Please don't try to respond to this on your own, because chances are there will be some sort of procedural error that will result in the agency, in the Office of Open Records, granting the request to the requester, simply because we never had a chance to deal with the substantive issues related to the case. Take it to your attorney, take it to your solicitor, and give them the chance to represent your agency before the appeals officer, okay? It's very important that you follow that. Okay, the product of an appeal is what we call a final determination. It's a legally binding order issued by our office. It looks like just what you would see coming out of your county common pleas court or the state's Commonwealth Court. Same format, same type of language, everything. Carries the weight of law. You can search for them on Westlaw or Lexis. We have to issue them within 30 days of receiving the appeal. Sometimes we ask for an extension if all the parties are in agreement. It just depends on the nature of the case. There is the option of mediation that's available that we detail in the notice of appeal. Sometimes you just get the impression that the parties aren't talking to each other, and it can be as easy as a conference call. We have trained mediators on staff who facilitate the process. If the parties are able to agree to something, then great, the problem goes away. If they can't agree, then we put the appeal back into the normal process, but we only go into mediation if everybody agrees to do so. I simply put it out here because it's an option available. Okay, our decisions can be appealed, and they can be appealed by either party. If it's a local government issue, it goes to your county court of common pleas. If it's a state department, it goes to the Pennsylvania Commonwealth Court. However, the Office of Open Records is not a party to the appeal. Okay, the dispute is still between the requester and the agency. But you need to notify us within the 30 days window for taking the appeal, because we monitor the case. We may submit briefs. We may request to appear before the court. Just depends on the legal issue involved and how important it is. But our decisions can be appealed to these higher level courts. Just remember that it's established precedent because they carry the weight of law. All righty, so we are at the end of the presentation. I didn't see any questions come through. Oh, what happened? Well, I didn't see any questions come through. And I'm going to just double check here to make sure that I didn't miss anything. But no, it looks like no questions. But if you have any, now's the time to get them in. We're at the final slide, so I just want to point out, I've been talking about the website. If you sat through another webinar, you know what I'm about to say. This is the best government website you will ever encounter. It's updated 6 days a week with new information, new court decisions, new decisions from our office. I mentioned the final determinations database. There's over 30,000 decisions in there issued by our office, where you can search on them through various parameters. Maybe you can put in your name and something will come up. Maybe, you know, your borough, your township, your school district, whatever, and see what sort of appeal activity you've had. There are guides for citizens, guides for agencies. If you happen to be an agency open records officer, we have a guidebook for you, 78 pages that you can download for free. If you're interested in more training, there is a whole page on the website dedicated to training resources, announcements like these webinars and so forth. If you're a real geek about government transparency, you can subscribe to our X feed. And every morning at 7 a.m., we will wake you up with all the news for the day regarding government transparency. Okay, question has popped up here. We want to be customer friendly. Is it better to document a records request by having the requester go through a formal records process? Or is it okay just to hand out a public record without an official request? Okay, Susan, you know, I think your question is, it's going to depend on your experience. My preference, and you know, I cover this with some of the beginning slides, is just hand out the records, or better yet, put them on your website and let the person download them without ever having to file a right to know request. Okay, that would be, in a perfect world, that's how the system should work. Okay, and that's my opinion. However, I have encountered situations where the agency required a right to know request. And when I talked to the people, they had a pretty good reason for doing so. This goes back many years, but there was a long history. There was actually a death involved with the police department, and they said, okay, if anybody wants these records, they have to submit a right to know request. And given that specific set of circumstances, it made sense. But like I said, in a perfect world, I just give the records out. They are public, you know, and why make it any harder than it needs to be to get copies of those records? But you may have a legitimate reason for requiring it, it's up to you. Okay, what has been a good formula for establishing a right to know fee? Well, the formula is that you have to do what we tell you. And that's based on the fee schedule on our website. Okay, so take a look at that. When you look at the fee schedule, be sure to read the footnotes, okay, because that goes into explaining them a little further. You do not have any leeway in establishing a right to know fee. You have to follow the fee schedule that the Office of Open Records establishes that is assigned to us through the appropriate provision of the right to know law. Can you block email senders such as FOIA Buddy? No, you cannot, okay? Our office is aware of FOIA Buddy, and we have released, most recently, a final determination that deals with that whole issue that might be able to help you out. But FOIA Buddy is a legitimate avenue for submitting a right to know request, even though they have put out a lot of misinformation on what they are. So you still want to process those requests. Take a look at our website and some of the announcements, some of the bulletins that we put out regarding FOIA Buddy, and it might make your life a little easier, but you cannot block them. Okay, volunteer fire companies, it depends, okay? I wish I could give you a definitive answer. Every so often we hear that the legislature is going to release an amendment to the right to know law that clarifies the status of volunteer fire companies, but there are some volunteer fire companies that are subject to right to know, some that are not. It depends on a laundry list of criteria that the courts have given us to use to analyze how closely associated the volunteer fire company is with the government jurisdictions that they protect. Okay, unfortunately, that's the best I can do. Okay, Susan B., you also mentioned realtors. You can't block them, but depending on the records that they're requesting, like I said during the presentation, take a look at the cost aspect of what it is they're asking for. And are they willing to pay a fee for the records that they're requesting? And that might very well solve your problem. Okay, is it a personal preference to give out public records without a request? Okay, Bryn, I think I understand your question. It's the agency practice as to whether they're going to require a right to know request or not. Okay, they just need to be consistent with that process and that practice. They can't arbitrarily say, we're going to give out the same records, but to you, we're going to require a right to know request. To this other person, we're just going to give them out. Okay, they need to be, cricket about the whole thing and make sure that they're treating everybody the same. Okay, Herbert, should I respond directly to requesters or forward the request to law with the records attached? Okay, I'm not sure what you mean by law. If it's your law department where your solicitor is, that's an internal decision as to what your practices are. My advice is that, look, if the record is clearly public, and there's no questions involved, why do you need to get your law department involved? As the agency open records officer, you're expected to know what you're doing. So give the records out, unless you're uncomfortable with it and you believe it needs a legal review. There's got to be time and costs involved with your legal department or your solicitor, and if you can avoid that for legitimate reasons, then do so. But again, that is an internal decision to your agency as to whether you believe that needs to be followed or not. Okay, Jennifer, if you get a right to know on records, but they are on our website, can you just direct them? Well, yeah, I've mentioned that a couple times. There's a provision within the right to know law that says
If someone requests public records that are also already electronically available, all you need to do is give them the URL for where they can find those records online. Okay, and that's all you need to do. Okay, Bryn, yeah, you're welcome. Any other questions, folks? Looks like everybody woke up here at the end, and that's fine. These are good questions, so keep them coming. I'm going to stay online here for just another minute or so in case any other questions come through. But yeah, all good questions and all things that, yeah, typically you should be aware of. Okay, well, it looks like we're wrapping things up here. No more activity. So I want to thank you for joining us today. We'll be back online here in 2 weeks with our next webinar. And get out there. Oh, there's a flash drive that has been recorded, then transcribed to paper, a public record if cleared. The flash drive that has been cleared would most likely, you know, it's going to depend on, the flash drive itself is not a public record. It's going to depend on what is on the flash drive. And are those documents public records? Okay, so let's say the records on the flash drive have been deleted. And I think that's what your question is asking. Yeah, first off, Ann, I see your meeting minutes comment. Let me answer the first question about the flash drive. If the records can be retrieved using commonly available software, and a lot of times, you know, if nothing ever completely goes away, if you can do it in-house and it's easy, and those records can be retrieved without any, you know, bringing in an expert or any sort of forensic stuff, then if they are available, then yes, you would be obligated to recover them. But if they've been written over and they're no longer available, well, then they're no longer available. So you wouldn't have to do it. Now, meeting minutes are clearly public records, okay? No doubt there's nothing secret about meeting minutes. And they should already, you know, probably be posted online. But, you know, if they've been wiped from a flash drive, it depends whether you can retrieve them or not. If you can, I would go ahead and do it. But for the most part, you're not required to do so. Okay, Susan, are there any current discussions regarding requesters abusing right to know? You know, this comes up periodically with the legislature where they're talking about, there's a term that's bantied around called vexatious requesters. It usually never makes it out of committee. Occasionally one house will pass a provision that updates the right to know law, and then the other house fails to pass it. I've been in this business for, gosh, you know, close to 15 years, and I've seen it happen over and over again. It just doesn't make it out of committee. So while there may be somebody talking about it, there's nothing serious going on right now that I'm aware of. If you have a concern, contact your legislator and let them know about your concerns. I mean, they're there to work for you, so, you know, go ahead and do it. Okay, Brian, if someone submits a request for an incident report, however, uses broad terminology. Okay, I'm going to assume you're talking about a police incident report. There is a Commonwealth Court decision that says police incident reports are inherently investigatory. Therefore, the 708B16 exemption applies, which covers criminal investigatory records. Therefore, an incident report is not a public record. Okay, so you can withhold it based on that court language and the B16 exemption. Okay, if they use broad terminology or incorrect dates, how far do we have to search for a report? Okay, well, you have to conduct what's called a good faith search for that report. And, if they're using incorrect dates or something like that, I would suggest reaching out to the requester and clarifying the dates. And if you cannot locate the report, if you truly do not have it, then you're not required to provide it. But if you do have it and the person's just asking for the wrong report, I think that's playing a little fast and loose. But the bottom line is that based on that court decision from the Pennsylvania Commonwealth Court written by Justice McCulloch, incident reports are not public records. And we cover that in another webinar that we do, Right to Know Law for Law Enforcement, where I go into that in a little more detail. Okay, good questions coming here at the end. Any more? Okay, I'm going to sign off at this point. But again, thank you all for your participation, and we'll be seeing you again possibly as soon as 2 weeks. Take care.